Welcome to the debate. Today we're tackling, well, one of the most persistent constitutional challenges in American politics, the question of statehood for Washington, D.C. The core conflict here really pits the democratic rights of, hundreds of thousands of Americans against the unique structural need for a non-state federal capital.
And that conflict is exactly why we're zeroing in on this specific strategy, H.R. 51. It's basically an attempt to sidestep the whole amendment process, which is obviously long and difficult, and instead just use a simple act of Congress. But, well, that choice really opens up some significant constitutional questions the founders might have deliberately wanted to keep closed.
Exactly. So our central question for today is this. Can using a congressional statute, one that shrinks the existing federal district down to just a tiny enclave, can that actually work? Is it a constitutionally sound way to fix the disenfranchisement issue? Or does the capital's unique status, especially with the 23rd Amendment still on the books, mean an amendment is the only way?
Right. And I'll be arguing that this statutory path is, well, constitutionally very questionable. I think it fundamentally goes against the founders' intent for the seat of government and creates some really intractable structural problems that just demand the higher bar of a constitutional amendment.
And I'll be taking the position that the power the Constitution gives Congress here is actually quite clear and broad. The statutory path isn't just appropriate, it's arguably necessary. And the legal objections people raise, well, they're mostly policy preferences disguised as constitutional mandates.
Okay, I understand that perspective, but I think I approach it from a fundamentally different structural viewpoint.
My starting point is really the admissions clause. This clause is, well, it's Congress's main tool here. It grants them really expansive power to bring new states into the Union just through legislation. H.R. 51, which proposes the name the state of Washington, Douglas Commonwealth, is basically just Congress exercising that power. It respects the need for a federal seat of government by carving out this tiny essential capital enclave, just the White House, Capitol, Supreme Court, the core federal buildings. The vast majority of the people and the land, they become the new state. This directly addresses the disenfranchisement. And, legal scholars have argued for a long time that objections about the new state maybe not meeting some kind of implied standard, like population or diversity of interests, those are really just policy arguments, not actual constitutional limits.
That's an interesting focus on the admissions clause, but I think it overlooks the whole structural history behind the district clause itself, Article 1, Section 8, Clause 17. This statute-based plan, it immediately creates some deep constitutional issues that I think really undermine the basic structure of the Republic. You have to remember the Philadelphia Mutiny incident in 1783. That's key here. It showed the founders very clearly that the federal government absolutely had to be independent from any single state's control. Otherwise, it could be held hostage by a state militia or pressured by local politics. Granting statehood to the area immediately surrounding the federal government, well, it fundamentally compromises that whole system of competing sovereignties.
But isn't that exactly why H.R. 51 creates that residual federal enclave? It specifically maintains the seat of government's independence.
Well, the problem is, I think, twofold. First, the historical precedent for shrinking the district, like the 1846 retrocession of Alexandria back to Virginia, that's actually quite shaky legal ground. The Supreme Court in Phillips v. Payne, they deliberately avoided ruling on whether that was constitutional. They relied instead on legal doctrines like estoppel, the passage of time. It's hardly a solid precedent for this kind of move. And second, you're creating this new state, Douglas Commonwealth, that is, well, structurally very unusual. It'd be only 68 square miles, less than 1/20th the size of Rhode Island, and it would be overwhelmingly dependent, economically and politically, on the very federal government it's supposed to be a check on. This new state, it arguably fails the test of being a proper Madisonian society, which, requires a multiplicity of interests to prevent any single faction from dominating.
Okay, you've jumped ahead a bit to the dependency argument, but let's first tackle the mechanism itself, the carve-out. Are you suggesting Congress actually lacks the authority to change the district's boundaries, especially regarding the land Maryland originally gave up?
Precisely, yes. We really need to look closely at that Maryland Cession Statute. The transfer, I would argue, was implicitly conditional. It was made only for the specific, limited purpose of creating the permanent federal district under the District Clause. So if Congress now tries to repurpose this land, not as a federal district, but as a new separate state, well, that's a completely different purpose. Doesn't the admission clause itself, which says you can't form a new state within the jurisdiction of any other state without that state's consent, doesn't that imply Maryland's permission might be needed again? The land was granted for a federal function, not just to be turned into a state whenever Congress feels like it. There are attorney general opinions going back decades suggesting that once the seat of government was fixed, Congress actually lost the authority to redefine the district's boundaries without an amendment.
I'm just not persuaded by that conditional grant argument. I think the actual language of the Session Statute cuts against any idea of a lingering reversionary interest for Maryland. When they ceded the land, the wording was forever ceded and relinquished, in full and absolute right, an exclusive jurisdiction. That sounds pretty unconditional to me. Maryland gave up all its claims. And look, the 1846 retrocession back to Virginia, even if the Supreme Court dodged the constitutional question later, it still happened. Congress successfully alienated a large chunk of district territory. That action itself suggests Congress has sovereign authority over the area, enough authority to carve out the state of Washington, Douglas Commonwealth. The consent requirement you mentioned in the admission clause, that only kicks in if the new state is formed within the jurisdiction of an existing state, and the federal district hasn't been under Maryland's jurisdiction since what, 1801?
Okay, perhaps you can argue away the Maryland consent issue by sticking strictly to the session language. But even if you technically win that point, you immediately run into a truly intractable problem that no statute can just wish away. The 23rd Amendment.
I disagree that it's intractable, though. H.R. 51 directly acknowledges a 23rd Amendment. It specifically sets up expedited procedures to repeal it. The bill recognizes that the amendment, the one giving the district 3 electoral votes, obviously needs to be dealt with once the district shrinks down to just that tiny capital enclave. So it initiates the Article 5 repeal process basically at the same time statehood is granted.
Right, but that's a political promise, not a constitutional fix. The moment the bill becomes law, the remainder of the federal district, that tiny, maybe 6-block capital enclave, is still constitutionally entitled to 3 electoral votes. 3 votes, the same number as the least populous state, potentially cast by, I don't know, a few dozen residents, maybe just the president and their family. I mean, think about how absurd that is. Attorney General Kennedy pointed this out back in '63 when the amendment was ratified. He said it was inconceivable that the states would have ratified an amendment giving 3 electoral votes to a district which had no population at all. Passing this statute pushes the 23rd Amendment into just constitutional absurdity.
Okay, but that absurdity stems from an existing amendment, right? It's a policy consequence. It doesn't actually mean Congress lacks the power to admit the new state. If the outcome is a ridiculous allocation of electoral votes for the tiny remaining district, well, maybe that provides the necessary political urgency for the states to finally ratify the repeal. The statute doesn't create the problem. It just forces everyone to confront the constitutional anomaly left over by the 23rd Amendment and mandates that we finally resolve it.
But forcing that resolution through an uncertain state-by-state ratification process after the Statehood Act is already law seems incredibly irresponsible. You're putting the entire electoral system into potential legal chaos. Let's circle back to the founders' intent and the structural problems inherent in the land itself. The whole point of the federal district was independence. The federal government must be independent of the states. This proposed Douglas Commonwealth would shatter that independence because it would be a state uniquely, deeply dependent on the federal government.
Wait, but isn't some level of dependency true for many states? States that rely heavily on a single industry or specific federal installations or land use? Are you saying Alaska, for instance, which is hugely dependent on oil revenues and has vast federal land, is somehow structurally unsound? Should it not have been admitted? Dependency seems like a policy challenge for Congress and the new state government to figure out, not, a fundamental constitutional barrier to admission.
I'd argue it's a difference in kind, not just degree. This new state would get something like 5.5 times the national average in federal funds per person. Maybe 2/3 of its workforce is tied directly or indirectly to the federal government. This isn't like Alaska and oil. This is like a state being utterly dependent on its primary resident, its landlord basically, the federal government, for its entire economic and social structure. A state so fundamentally intertwined with the national government just could not act as a check upon it. It risks becoming sort of the imperial state, as some have called it. It really compromises the whole Madisonian idea of competing sovereignties. I just don't see how this entity could function as a truly independent sovereign within our federal system.
Okay, I understand the point you're making about fiscal dependency, but I still believe that objection is, as I said before, strictly a political one, dressed up in constitutional garb. The Constitution itself only requires that a new state have a Republican form of government, right? Which H.R. 51 ensures. This historical standard you mentioned, needing a multiplicity of interests, which Madison discussed, that was really aimed at American society as a whole, ensuring no single faction could dominate the entire country. It wasn't meant as like a rigid checklist for every single state. I mean, think about Utah when it was admitted, overwhelmingly Mormon, or some of the early small states. They had unique dependencies and certainly lacked broad diversity. Plus, the district's population today is larger than 2 existing states. The constitutional case against admission based on size or dependency just doesn't seem strong enough to override Congress's clear power to admit new states.
The problem remains structural and, frankly, geographical. We're talking about 68 square miles, a 20th the size of Rhode Island. That incredibly small area, combined with the intense economic and political homogeneity, it means the Douglas Commonwealth is just inherently different from the kinds of sovereign entities that have traditionally joined the Union. And look, the history of past efforts suggests this unique status of the capital really does demand a constitutional solution. Remember the proposed 1978 amendment to grant D.C. representation? It failed, but its very proposal showed that a change this fundamental likely requires the broad consensus of the states via amendment, not just a simple majority vote in Congress.
Well, the fact remains that the statutory path laid out in H.R. 51 offers a direct legislative fix for the disenfranchisement problem. It does so by exercising Congress's pretty clear and expansive power under the admission clause. Yes, the resulting state and the tiny residual federal enclave would be unique, absolutely, but the constitutional standing of the new state rests on solid ground, I believe. Congress has sovereign control over the territory, and the legislative action simultaneously demands that we address the constitutional headache left by the 23rd Amendment.
But we have to respect the founders' core requirement that the seat of government remain independent from any single state's influence. Moving ahead with H.R. 51 purely by statute risks creating these profound immediate constitutional problems, especially those 3 electoral votes for the tiny enclave. And it establishes a state that is just too dependent, too politically monolithic. It lacks, I think, the necessary structural independence for genuine sovereignty within our federal system. It ultimately seems to defy the spirit, even if maybe not the absolute letter of the original constitutional compromise.
The material we've looked at certainly demonstrates that any proposal for D.C. statehood, whether it's through statute or amendment, it's deeply tangled up with the core constitutional bargains made at the founding. It really reminds us that, while any path forward means navigating some very deep historical and legal tensions.
Absolutely. And there's clearly much more to explore here regarding this fundamental tension between the democratic rights of the citizens who live in the capital and the functional structural necessities of maintaining the federal government's independence.